Welcome to Challa Law's weekly immigration webinars. I hope you all had a safe weekend and are doing well in some capacity. We're going to talk about a couple of different things with regard to immigration and what's on the horizon. For all of you who are new to join, I want to welcome you to our weekly webinars. For those who are joining for the first time, I'd like to, joining, has been continued to support our weekly webinars. I want to thank you again for joining. So I was going to give it a few minutes to get started. Two things I found out recently. One is Senator Zoe Lofgren, who you all know is responsible for a lot of pro-immigration initiatives. One is, like removing the backlogs for green card holders. Her staff attorney that is working with her on business immigration was actually one of our interns. So I was great to connect with her over the holidays and share some information about our thoughts on the various changes and reform that needs to be made within immigration. And on Friday, I'm part of API 100, that's 100 Asian Pacific Islanders, and we had a call with the head of Biden's White House Director of Interagency. And one of her major issues, Ms. Rodriguez, is immigration. So we got to chat a little bit. We exchanged contact. So I will be reaching out to these resources to see what the buzz is on the Hill and what the buzz is, basically within the Biden administration about immigration reform specifically. So keep connecting with us so you can get the information, tell your friends. You can connect with us on various social media platforms. We would love that. We use the various platforms for different types of, immigration initiatives. Always check out our YouTube videos. There's a lot on there that is applicable to everyday issues that you may be going through. Like if you want to know about CSPA, or if you're concerned about the PERM process and what needs to be done, whether it is H-1B and roving employees, and do you need a new amended petition? We've got the answers for you, and they're on our website. They're on the YouTube channel. So subscribe if you find it helpful. Share with your friends. We want to make sure that we're able to disseminate the information to as many people as we can. So today we're going to talk about the updates on the H-1B, wage selection, other immigration bills, trying to make sure you craft your immigration strategies. As always, we're going to take the questions at the end of the session, and please post your questions to the Q&A instead of the chat. It just makes it easier if everyone uses one platform for us to get to as many questions as possible. So let's get started. Wage-based immigration registration. This was introduced. The Trump administration is trying to, under Ken Cuccinelli's lead, is trying to get as many initiatives to curb immigration as they possibly can. One of them was the DHS wage selection for H-1B. I think this is going to be, I don't think that they will use this process, but, and I think there's a lot of challenges to it, but, it is important to know that what is on the horizon, and we want to make sure it gets addressed before the H-1B season. But it's basing the selection on wage versus please slide your video. Video to the, okay. There we go. whoops, on wage selection, so that, and like I was stating, somebody asked me to shift my slide over so they could read it. But that is the crux of it. It's using wages, which would be detrimental to universities. It would be detrimental to folks that are physicians that are working in underserved areas. So it's really a problematic issue. So I think they will still be maintaining the registration component to what was introduced last year. I think that worked fairly well. And that way, companies don't have to file unless they're actually selected. But the basis of this is because it's going to be selection on wage. They're stating that if you subsequently, kind of inflate the wage just for the selection process and subsequently file an amended petition to lower the wage, they will actually deny the petition. So like I said, there's going to be a lot of challenges to this. And I think more importantly, the head of DHS is, and many people throughout the Biden administration have stated that they're going to make sure that it is more business friendly, the immigration. I know everyone keeps hearing about the illegal immigration issue, and that's because you're talking about separated families. You're talking about really horrible, horrible conditions. It's more of a human rights issue, not that business immigration is not. But even though you don't hear about it as much, it is on their radar, and that is something that will be addressed. And so even notwithstanding this, one of the things that we've stated here is ensure the position and SOC codes match the role opportunity. We see this a lot with cases that have been brought over where other attorneys' offices have prepared, the initial H-1B stay, and we're doing the extension. That attorneys often don't pay much attention. A lot of attorney law firms just, will place the employee in software engineer, or they won't ask enough questions of the employer to assess what exactly the actual job title and SOC code could be. Why is that a problem? Even right now, on the LCA, the employer affirms under penalty of perjury that they are paying either the higher of the actual wage or the prevailing wage. The actual wage is what they pay employees with the same education and experience for that particular job at that same location. So that's why it's really important to pay attention to that. The other thing is, if it's ever questioned that whether that position is an H-1B position, one of the ways the employer can demonstrate that it's an H-1B position is by showing evidence that, for example, all their employees within that particular designation are degreed. So to give you an example, there was a company that they had a user interface individual because they do website designs for complex legacy systems. And they sent over a description for software engineer. Well, actually, so if that was ever challenged, if we didn't probe and say, hey, it's really not software engineer, it's user interface. Here is another classification that I think closely aligns with that. When the RFE, if we didn't get an RFE, but if the RFE had asked, is this an H-1B position? Well, all their user interface individuals have a degree specifically in that area. So that's why it's important, notwithstanding the regulations that are in the pipeline. The wage rule that was first implemented in October has been modified. An advanced copy was made available yesterday, and the effective date is 60 days from the date of publication. And they modified it because if you remember, it was challenged and there was a nationwide injunction placed on the new wage rule. So they're trying to overcome whatever the federal court said in terms of why it was not enforceable. I think one of which was that they didn't meet the notice and comment period. But again, we'll have to see how quickly. I mean, basically what they're trying to do is inundate the system with so many changes that it would take a long while for the Biden administration to address all these changes. But one of the things we're trying to do is kind of put together a list of all the things that they need to address early, so that, you know, sometimes people who are within the process or within the administration may not know what's happening on ground. So that is one thing that Challa is committed to, is making sure that the new administration understands the more kind of secret changes that are taking place that may not make the newspapers and may not be on the radar. The new wage protection rule, here's the new way that they're updates to the computation of the prevailing wage levels. It is, like I said, ridiculous. And it really hurts. Again, this hurts those really critical jobs. I mean, it's not only for individuals that are looking for extensions and so forth, but it hurts people who are working, again, in underserved areas, universities, research centers that may not be paying, you know, the higher wage. And we did, when this first came out, had a webinar specifically that addressed alternative wage surveys that are available. Now, because this does not take effect for 60 days, we're pretty sure that this also will not survive. But nevertheless, it's our job to let you know, not just the predictions we have for things that we think will be in play or effective, but also the what is down the pipeline, so you can see what needs to be, that may need to be addressed. Now, as I stated, the prevailing wage levels must be set commensurate with education, experience, and level of supervision. And that's always in effect. So this is something that really people should take seriously. What is your job title? What are the specific duties? What's the education experience that's required for the job? And I think that's really important for a number of compliance reasons. So the DOL wage protection rule now is going to change how they look at wages paid to U.S. workers and prepare a master's degree, you know, and focus on high users of the H-1B program. So it's really targeted to curb, you know, H-1Bs specifically for, you know, consulting companies is often the target of that rule. Biden indicated last night that he would take action to eliminate midnight regulations, last-minute policies that are not yet effective on Inauguration Day, and he would halt and delay the regulations, but also issue guidance documents. Many of them have been struck down by courts, so we will be taking an active role in trying to make sure that they know that it's on the horizon, and you know what the effect is to individuals and companies that are having to go through this. Bills on the horizon. So the Senate unanimously passed 786. You know, that is the country cap rule. And as you know, that it allows a 45 to be filed after the I-140s have been approved for 2 years, regardless of whether the visa number is available. So you know, this is good, but it's only going to be a temporary solution. I mean, I think this provision, which allows the 485 to be filed after the I-140 has been approved for 2 years, regardless of whether the green card is immediately available or not, is a great provision to address the backlogs, which will come again, even if they outline the removal of the current country caps. So EADs will be issued in 3-year increments. The new amendment limits H-1B, H-1V holders who have held the status in the past 2 years, who can adjust status 70% of the total number of employment-based periods for the 9 fiscal years and thereafter. So unused visas may be redistributed to H-1B and H-4 non-immigrants. Exceptions are doctors and national interest waivers. And it prohibits green cards for individuals affiliated with military forces of the Republic of China or Chinese Communist Community. It eliminates the do harm provision for employment-based visas. The new provision delays the effective date of the per country caps to the 2nd fiscal year after enactment. Increased transition period for EB2 to EB3 from 3 to 9 years. And it increases the number of visas in these categories other than China and India to 30% and reduces it by 5% each year. Supporters of the bill applaud the bill for ending nationally discrimination for the visa allocation backlogs and clearing backlogs for Indian Chinese applicants. But it could create a backlog for other countries. And what I have been saying when legislators or other people have brought that up, I have said, well, India and China have faced a backlog for a number of years. So many people have children aged out. They have to send their kids to Canada or some other place, And so since it will equal out eventually, I think the fact that it initially creates a backlog for other countries should not be a reason not to support the bill. And it would help our ability to continue to attract global talent to the U.S. And although the Congressional Research Service confirmed that the bill does not alter the growth of future backlogs, they said that it would initially reduce wait times for India and China, but increase wait times for other workers in other countries. But it doesn't add green cards. And, like I said, I think there needs to be a system overhaul. This is definitely, I know for the people that are hurting right now, a good sign and something that they're looking forward to. But I wish that there would be more of a holistic solution to the problem so that we don't have to go through backlogs again. Presidential proclamations are extended to March 31st. That's probably going to be another rule that Biden shuts down. Biometrics expansion rule. The final rule is in draft. Then the DHS elimination of duration of status rule. If you remember that, F1s and J1s, when they come into the United States, are DS. That means their I-94 says they're here for the duration of status. And that's because they can go from one academic program to another without having to worry about the expiration of status. Now, duration of status doesn't mean that they can't, the F1s still have to maintain status. That means full-time study. There are certain limitations to how many online classes you can take. Originally, it was just one. Now they've transitioned to hybrid because of COVID. And then, of course, you've got to, OPT and making sure you've got the validity of employment, whether it's STEM OPT or regular OPT for the requisite time period as outlined in the regulations. So previously, when it was DS, that means that an F1 student couldn't accrue unlawful presence in the U.S. unless it was adjudicated by a judge. So they are trying to eliminate that so that, and the reason why they did that originally is sometimes the status issue is more because maybe SEVIS didn't get updated by the school through no fault of the F1 student. So that because there's so many other factors that play for F1 students, they didn't want to impose unlawful presence on the students without a thorough adjudication where the student would be able to be represented by someone who hopefully understands the law. So that final rule is in draft, and the affidavit of support proposed rule is also in draft. I mean, like I said, they are trying to really fill in as many restrictions as they possibly can. And if you're joining me late, and here are some others that are in the pipeline. If you're joining me late, as I stated earlier in the program, we are actively engaging in alerting the people with the Biden administration what all, this series of changes, all the way from the removal of discretion for H-1B extensions and to, the third-party placement rule, all the ones that have been overturned by federal judges, and to make sure that we can go back to some semblance of a pro-immigration friendly administration. So we'll keep you posted on those changes. So make sure you tune in and connect with us on the various platforms. With these changes in mind, and once I should know within maybe the next 10 days what some of the strategies are in play for the Biden administration, for the first year or so. And it's a good idea then to make sure your immigration strategy is appropriately, put in place so that you can leverage the benefit of it, right? You're not being reactionary to a new rule that's in place, but you're actually being proactive, and so you can get the maximum benefit out of the changes that are coming up. So fingers crossed. That's why connect with us. If you're not on our Challa chat forum, please join the forum. We've got one for H-1Bs and H-4s. We've got another one for E-3 visa holders. And if you connect with us on these forums, we'll be able to, like I said, disseminate information fairly quickly to all the groups. And so if you are, share it with your friends, because like I said, my Challa Law intern now currently works she's a staff attorney for Zoe Law Firm, so we can find out what's happening about the backlog. I'm going to be communicating with the White House director for interagency head on immigration. And so there'll be some very critical updates that we will be posting. And you can connect with us on all these various mechanisms, Facebook, Twitter, Instagram. And I think my team just posted the link for that. And so please join us on those various platforms. View recordings of our previous webinars. Like I said, we've got one on alternative wage surveys and how they can be used. And that may be helpful to know, not because of the new impending rule that probably will be invalidated, but it just may be a good thing for you to know or utilize otherwise. So, and if there are specific topics you would like me to address, it doesn't have to be on the webinar, but whether it's on the webinar or just something you want me to illustrate, I'll be happy to do that. You can email us at info@challalaw.com. We're getting ready for our Q&A, and if we're not able to get to your question today, please make sure you email us. And like I said, we do this every week. My team works really hard to put this together. It would be, I keep getting emails from people saying, thank you for doing these webinars, are very helpful. The Q&A is really helpful. So I'm asking you today, if you can email 5 of your friends and give them the links to our Telegram group and our weekly webinars, that would be a great, thing you could do for me. I'd really appreciate it. Now let's turn to our Q&A, and we're going to welcome Attorney Challa, who's going to be the moderator. How are you doing, Shaker?
Hello, how are you all? Can you hear me?
Yep.
Okay, because I have a new computer, so that's why I would want to make sure I am. All right, good afternoon, everybody. Hope you're all doing well. For those of you who track some festivals in India, or you're Indian and all over India or all over the world, today is Happy Lohri, the first of the 3 days of Sankranti festival, the biggest festival in southern India, the harvest festival. So we wish good luck to all the farmers in India. As you know, they're going through some tough times,
As all over the world.
The Prime Minister of India has some, heavy duty policies. So let's wishing all of you a happy Sankranti and
Yay! And happy Lohri.
And Lakshmi and myself. All right, let's go to the questions. See, the first one here is Sandeep Kaur. Hello, Lakshmi. Thank you for doing this webinar. Your webinars are always so helpful. You're very well aware about my case. I'm still stuck in India with 221G. My priority date on GC, EB2, and EB3, January 2011. Does consulate consider or give any preference on stamping if you are getting very sick in India due to pollution, food, etc., and also have personal investment and properties to take care in the US, as I have lived in the US for 13 years, as well as from India for the US military bank, which is my H-1B job. So that's the background. So a question, I'm qualified for O1 visa through investment bank job. Does it an option to file for that as well? Meanwhile, 221G is pending with Mumbai Embassy.
Yes, I think that would be, and the O1, the great thing about that would be that it would put you in the category of the national interest, of the United States. So I think that's a great, especially since I know what it is you're doing, and it's very critical work. So I think it would put you, in a better placement to get the emergency appointment. If you email us and include my team on the email, Sandeep, and we'll send you the O1 criteria, and then we can maybe have another chat. I know we spoke sometime back. You could just email us and tell us how you fit into the categories, and if need be, we can have a follow-up conversation about it. And thank you for your continued support.
Yeah, so just based on what Sandeep Kaur just made a comment, I'd like to correct myself and say Happy Lohri to everybody in the northern part of India. People celebrate Lohri. Southern part of India, it's Sankranti. So happy everybody. Anonymous attendee, next question. Can you please provide some update on the receipt notices for I-140, I-485 concurrent downgrade cases filed last week of October?
Yeah, the receipt notices is problematic throughout, whether it's for the I-140s or, the delayed processing times that concern students who are applying for their OPT. It is a disaster, an intentionally created disaster, I may add. But we're hoping, we've got 7 days till the new administration is in. And like I said, we are trying to highlight some of the more critical things that the Biden administration should address ASAP. One of the things, and I've said that before, there's a receipt notice and there's a receipt number. So if you look on the back of your cashed check for your filing, you should get, they do stamp it with the receipt number. So at least you would have that. That'll give you some comfort that it has been received by the USCIS.
The person wants to know, have you received any receipt notices for the cases your law firm has filed?
I believe we have, but not on the level of, and it's, the funny thing is, for some of the ones that were filed very early, I don't think we've received any receipt notices. And we received some that were filed later, which doesn't make any sense to me, but we've received a few, but not for all the filings that we have. So there's still a substantial delay, but we have been telling our clients, because for the most part, they send us the money for the filing fees and then we cut the checks. So we're constantly monitoring where the checks are cashed and sending them the receipt number so that they have that at least.
Just a follow-up question from Sandeep Kaur. She's asking, can you help me with O1 filing, etc.? I need good attorney for my case.
Yeah, we do. We've got, and we've done O1s for people from all aspects, whether it's entertainment, whether it's a business person. Usually O1 for business is difficult. This is a company that does, they prepare buffalo mozzarella in Colombia. And so he doesn't do the preparation, but he was, outlined the process and strategy for that. And that's usually a pretty difficult O1 to get approved, but we were able to do that. And, somebody who is a branding specialist to someone who specializes in monkey, preserved, or, animal rights activists. So it's all, and we are very good. My associate, John Milburn, is phenomenal in that. I love it too. I love O's because it's, they're challenging and interesting, and you get to find out about the person's expertise. So Sandeep, yes, we not only do it, but we do it extremely well.
All right, thank you. So Sandeep, send in your request and information as soon as possible. info@challalaw.com. Next, so just a comment from Sagar Kulkarni. He just says, I just want to thank you, Lakshmi ma'am, for all the information we get from your weekly webinars. This is very helpful.
You're welcome. Like I said, if you all like them and you're appreciative, please do, if you could do me that one favor. And I know Kara put the links up for not only our Telegram group, but for the weekly webinars. If you can send it out to 5 of your friends, we'd really appreciate that.
Yeah, send it to 5 of your friends, and I have those 5 friends to send it to another 5 friends. That's the way, build the chain. And let's say if we can build a voice in America, Karthik Rajashekharan is asking, I've got my I-140 receipt number for EB2 to EB3, downgrade new. Is it good to change it to premium processing?
Not now. And then you can't, if you did a downgrade and they don't have the original labor cert, you won't be able to get the premium anyway. So no. And I even if you're doing an H-1B, I've told everyone it's not a good idea to do premium processing right now. Wait till the new administration comes in. But for yours specifically, because it's a downgrade, you can't do a downgrade because they don't have the labor.
All right. Manidhar is asking, which is preferred during first-time COS stamping? F1 to H1 stamping from home country, or we can go to another country?
You can. We've got folks that do that in Mexico. And the reason is, I think during COVID, Canada, you've got to self-seclude for a certain number of days and before you could process. So Mexico is probably a better place to process. It is, I say that you can do it in a third, but it's very case specific. You've got to make sure that there's no irregularities in your case history to ensure that the process itself is seamless.
All right. Next one is from an anonymous attendee. Hi, Lakshmi. Thank you for your time today. I wanted to know what is the average overall cost for applying for an H-1B visa? And do you know how much of it on average can be covered by the employee versus the employer? Just wanted to get an idea. Thank you.
Right. So I'm going to try to explain this, and I think we have a memo on it that I can send you, but by law, the fraud fee and the employer fee must be covered by the employer, right? So within an H-1B petition, there's the attorney fee, there's the USCIS fee, there is the fraud fee, and there is the employer fee. So you have all these fees. Now, for two of them, the employer fee and the fraud fee, it must be paid by the employer by law. There's no wiggle room there. For the attorney fee, the USCIS fee, a premium processing fee, these are all deemed business expenses of the employer. So because the employer can deduct that from their taxes. So the formula for that to assess whether the employee has to pay for it or the employer is if you deduct whatever the cost of those fees are, and it would vary, then from your prevailing wage, from the wage offered, would it still be above the prevailing wage for that position? So for example, let's say the total cost of your attorney fee, the immigration, USCIS fee, and now the premium processing, which is $2,500, wow, is maybe $6,000. The position, the company is offering you $80,000 for the job. The prevailing wage for that is $75,000. If you subtract the $6,000 from the $80,000, you would be at $74,000, which would put you below the prevailing wage. That is not permissible. If, on the other hand, you're being paid $85,000, deducting the $6,000 would still put you above the prevailing wage. So in that case, the employee can pay for it.
All right. If there's any more clarification you need, just send an email, info@challalaw.com. Okay, let's go to Om Adhikari. I'd like to know if Challa Law helps with N400 representing the applicant who has some learning disabilities in their interview.
Yes, we do. I've helped a number of people with their, for the most part, I always tell people you don't need it, but if that is an issue, yes, we can assist with that. So email us, give us some details, and at info@challalaw.com, and me and my team will respond.
So Sandeep Kaur is going to be sending her request for the O1 very soon.
Good. And like I said, Sandeep, make sure to email. If you do it at info, it goes to a number of people rather than emailing me directly, because and that way your request gets more people to respond to that request than just me, because I get, probably since I've been sitting here, I'm sure I've got about 100 additional emails that have come in. So but the info@challalaw.com would be the best resource.
All right. Thank you, Sagar, for considering to forward our, webinar information to your friends. Karthik Rajashekharan is back. He wants to know which date is counted for 180 days. As I see I-485 as January 12th, but for I-765, it's October 27th.
The receipt
If I
date,
got a full,
yeah, it's the receipt date on your I-485.
if I got a full-time job, is it okay to join with 180 days of I-485 if my current company is in good terms with me and won't withdraw application?
No, because you have to, the I-140 has to be approved, and the I-45 has got to be pending for 180 days. So if the I-140 is not approved, it doesn't matter how long the I-45 has been pending. It's got to meet both those prongs.
All right. Money there is back. He says, I saw in few groups that Mexico does not allow first-time COS stamping. I have a situation. My special occupation code has been changed in my amendment and it is approved. Do I have to worry about anything when I go to visa stamping?
Well, we've got a great resource that specializes in that, and we may even invite him to be part of our webinar next week or the week after. We'll keep you posted. But let me check with him and see what he says. So email us at info@challalaw.com, and I will check with that contact in Mexico to see if there are any issues with that.
All right, let's go to Vinod. His question, if I have approved I-140 and I leave outside of country for a few years to Canada or somewhere, for how many years can I still be eligible for cap exempt H-1B visa and can still port existing priority date if I decide to come back?
The priority date is yours. And if you've got a cap exempt H-1B, and you haven't and you're outside if you've exhausted your 6 years and you're outside the if you've got an approved I-140, then that wouldn't even be an issue. So, and if there's time left on your H-1B, remember the key is if you've had an H-1B within the past 6 years, then you're not cap subject. If it is greater than that, then you would be cap subject.
All right. His follow-up question is, do you help with self-EB1 filing?
Yes, we do a vast number of those. There was a period where we were special counsel to the Attorney General for about a decade. So we have done, for all the universities, and we still get a lot of requests for those individuals. We had to withdraw representation because we were thinking of merging with a large firm that would have been in conflict with the Attorney General's office. But we do a large number of EB1s, and I actually will look at the resume and CV and say, whether I think it's a strong EB1 candidate. We haven't gotten a denial on EB1s for extraordinary ability or multinational researcher or professor. We have a very, and there have been people that I have told, you're not ready yet. You're not eligible. You have to meet these certain criteria in order to be, because it's not just, I don't operate just to take your money. I think I have a ethical obligation to make sure that if you are not eligible for the classification, then I shouldn't go forward and have you expend money, time, and effort to file it.
So there's a message on the chat from the office. It says they checked our O1 records, filing records, and couldn't find a single denial for at least 4 years. It probably does longer than that, but so Sandeep Kaur is very happy, and so should somebody else also who's looking for O1 filing. So.
Right, because the EB1 mirrors the O1 very closely. And we, like I said, it's not that we have been doing it just for like university professor, doing an O1 for a university professor or a physician. Those are easy. We did it for a branding specialist. We did it for, someone who came up with the idea of how to make buffalo mozzarella in Colombia. We've done it for chefs and artists. So, we've got a vast breadth of knowledge within the O1 realm and EB1.
So, if you're not sure about, whether you qualify for O1 or EB1, just send an email and hopefully, not hopefully, we'll send you more information so that you know exactly what's the difference and who's qualified for what. Next question is, here's an interesting question. Anonymous attendee, can you please do a webinar for small businesses wanting to expand to US, either through an L1 or a B1, and the future course for same to materialize to a long-term status?
Yes, I would be happy to do that. And I've been thinking about creating a Telegram group just for those looking to expand. And the reason why those groups, I create them based on the type of visa, because the information is different. What the H1B, people on H1B, H4s are looking for, people who are on E3 have different issues, and people who are doing, who are looking to expand in the US. And we have been, I think, through a couple of administrations, working with the Department of State and Department of Commerce to try to attract foreign direct investment into the US. And so we have, we've actually, there was one Brazilian company whose L1 or expansion, he was actually getting an extension on his 1-year new office L1, and he had hired a really large, very well-known law firm, and he got 2 denials. They filed it, it got denied. I mean, RFE'd and denied. And he filed it, they filed it again, it got RFE'd and denied. The individual had to take his family, his children, and go back to Brazil. And that's when the Economic Development Authority approached us and said, is there some way you could help them? So I think it's because we don't pigeonhole any one process, and I'll tell you why in a second, but let me finish with this story. So he asked us, I told him to try the E because he was eligible. And then he asked me to go ahead and file for the L1. I said, it's been denied twice. There is a mark on the record. He goes, but I have confidence in you. I think, and we got it approved. And now the Economic Development Authority just comes to our office and asks us to help. And even, Select USA that does foreign, they always will find me at the conference and they say, I want you to talk to this person because I feel like, you probably know your stuff better than most. And they, Select USA had me moderate an immigration panel with people from Fragaman, somebody I think was from Appleman, and large law firms. And the guy was a managing partner at Fragaman, and he was doing L1s. And I said, okay, with L1s, can you talk about EB5 too? Because I want to talk about strategies. He goes, no. I said, you don't have to go into a detail. Just talk a little bit about it. He goes, no, I don't want to talk about it. I'll talk only about L1s. The same thing with each of the panelists, because they get pigeonholed and they do only one type of process. What happens when you do that? You can't offer innovative solutions because you don't know about the other processes. Everybody at our office does everything. So I can tell people, if you're from an E country, why don't you do the E first? E's don't allow for permanent residency, but within 3 years, you can change to an L, and then through L, you can get permanent residency. And there are reasons for that. And so I would, and if you email me, I'd like to talk to you about how we can pull together and try to get a Telegram group, and do some webinars for companies that are interested in expanding into the US.
See, on that note, I wanted to plug in something that I do. I help people buy and sell businesses and franchises through Transworld. It's a Florida-based company here, Florida-based company, obviously in Florida. But so if you're interested in buying a business or a franchise, do reach me out. You can still, send an email to info@challalaw.com, or you can send it to cchalla@tworld, T for trans, tworld.com. So I'll be able to provide you more information. But I also wanted to just kind of pass on an information. I'm sure if you're a small business or you're self-employed, you know that today is the beginning of the round two of the PPP loan. So you need to get in touch with your bank. Not all banks have opened the application as yet. SBA says it starts today, but banks always take a little bit of time, maybe in the next couple of days. So what I'm trying to tell you is, you need to be in touch with your banker, whoever is the person in the bank, and say, hey, I like to, because it's always first come first, so keep on the lookout. As in, when, go to your bank website, that's where you will see, yeah, we are ready to accept applications, and boom, let's do it. Okay. So be alert on that, please.
Right. And what people don't realize is if you're looking for an L1 and, you don't have, much of a connection within the US market to grow your L1 business. The L1 that you set up in the US does not have to be related to the type of business you're doing overseas. Most people don't know that. So we had advised someone recently who did not have, there's I talked to a gentleman this weekend, his US entity has been doing business since 2015. And so he's got, a ton of documentation to show the growth and everything else. But for people, for example, that do not have the market connections in the US, it can be difficult to grow the company in the requisite time that the regulations state. One way you can overcome that is you can set up an entity and buy a franchise. The franchise, either an existing or a new, would help you grow in a more expedited manner while you are concurrently trying to grow whatever other business you have. So you can meet the regulatory requirements and still grow your business, and you've got revenue coming in. So that's when we decided to partner so that, the immigration and the business side kind of align, and there's some synergy with that.
So while we're talking about the different alternatives, I just want to plug in another aspect of what I help most of the time. The front end is on the EB-5 visa. With all that's going on with the employment-based categories, the backlog for Indian applicants has considerably reduced. And with the new administration coming up, we hope that the processing time will speed up. So if you have resources and you're looking to file an EB-5 visa, you're looking for one, just send us an email. I'll be glad to talk to you and give you more information. And once you're happy with all the questions and answers that you received and clarifications sought from me regarding just the basic process, investment, source of funds, and tracking funds, and all that stuff, then you can consult Lakshmi for the immigration aspect of it. All right. So let's resume our Q&A. Sorry for the digression here. An anonymous attendee is asking, I'm working on H-1B level 3 on a salary of $95K. Due to COVID slowdown, my employer is thinking to reduce my work responsibility as well as salary. Can he change it to level 1 or 2 and reduce my salary? Could that be a problem for my case, renewal, etc.?
If you can hold off on doing that for at least 2 weeks, I think we can have a clear sense of how you can manage that. You can either do that, I think reducing the role, typically is not a problem, but this administration is looking at that with kind of a laser focus. Another way in which you can is go down to part-time status. So you can do, 30 hours can be part-time status. And that way, you're not effectively saying that the role has changed, but your hours that you're investing have changed. And so if you go from 40 hours to 30 hours, you can still meet that wage that your employer is willing to pay. And that's basically straightforward. So if you need any help in that, we've assisted a lot of companies navigate through that process. Email us at info@challalaw.com and we can help you.
All right, the next one is another anonymous attendee. I was looking to travel while I'm on my H-1B visa. I would be traveling for the first time since being on H-1B status. Is there any way to get my process started and appointment set up before actually going to the country? Do you do assistance with this process?
Well, you can do that through, you'd have to qualify, because you wouldn't qualify for the Dropbox. You'd have to qualify for, in this current situation, an emergency appointment. Again, if you can wait for 2 weeks, the change in administration may change, the backlog for visas. And so you may not have to even qualify for the emergency appointment. So give it some time.
So Aman is asking, I already have an approval I-140 EB2 from my previous employer. I'm working with John to file my new perm through new employer. Should I file under EB2 or EB3?
Well, if you want, you can file under both, if it's crafted that way. And, you can, if they're filed if people don't realize this, but with one perm, you can file both under EB2 and EB3 if it's constructed in a certain way. And you can file that because by the time you get to file that, we'll be in the Biden administration. You can file that premium processing. And so you would get an approved EB3 and EB2 at the same time. And so you can utilize whichever one works for you. And your priority date would port to both of them, your previous priority date.
Next question is from an anonymous attendee. I have my green card and applied for I-824, followed to join for my family, and it is approved. After that, I have filed immigrant visa IVDS 260 for my family back in India and waiting for consulate processing from Mumbai consulate. Can this be expedited?
It probably will be in a couple of weeks. Like I said, you'll have a new administration, so keep checking in with us. And if it doesn't, there are a few ways in which you can try to get it expedited, but I think even if you try that now, it wouldn't, it's going to take some time. So I think that if you give it 2 weeks and you keep joining our webinar, I can tell you what's going to happen on that front. Like I said, I'm going to be communicating with the interagency Biden head and letting them know that these visa backlogs and the non-issuance is a big problem, and the receipt notices and all the other things. So I once I hear back from them, then I'll make sure that, on our various platforms, Telegram and in our webinars, that we let you know what we know.
I think this will be the last question because we're closing at 1 o'clock, right?
Mm-hmm.
So if we are not able to get your answers, I think I got 2 more questions. So we'll stop with 2 more questions, and then, but before I go, I just wanted to throw a small, tidbit out there, and this is based on, I saw some talk going on about Major League Cricket in United States. So I know some of you are, let me rephrase. If you have played cricket in India, A-League, Ranji Trophy, or whatever, right? Maybe you could check with Lakshmi and see if you can be, qualified for extraordinary ability or something, because Major League Cricket is starting in 2 years. There's some initiation in Texas.
Mm-hmm.
And I think Lakshmi if somebody's talking to our office on that. So I just wanted to throw that because, my fellow Indians out there, who played A-League cricket or Ranji Trophy or whatever, she can determine whether in consultation with Major League Cricket Organization Authority, but hey, T20 One Day International is all going to come in 2 years. So that's
exciting. That's really
that. And, and if any of your kids are playing cricket right now and you think are very good, hey, they could be a part of extraordinary ability, and maybe Major League Cricket organization will sponsor or something like that. But I just wanted to throw that at you. Maybe you can just talk about it yourself, and then reach us. And on that note, just like to wish Virat Kohli and his wife to become parents of a newly
Oh,
born. Yep, our Indian captain. So let's
thank
wish
you.
India today for the last test in Australia. All right, let's go to the last. My mother is on B2 visa. She had 10 years multiple visa and is expired in August. She came here on January 1st, 2020, and her I-94 expired on June 30th. We did not file her extension on time as we thought that COVID flight cancellations would be considered as emergency and will take care of status. But we filed extension on November 10th and got receipt notice and check encashed November 12th. If she leaves now without getting the fingerprints done, will it be an issue?
Yeah,
We don't
she's
know
been,
when they.
oh, I'm
We don't know
sorry. I
when
was
they.
going to say, yeah,
Go ahead.
go ahead.
Just want to complete what the person is asking. If she leaves now without getting the fingerprints done, will it be an issue? We don't know when they give appointment for fingerprints. If she leaves before fingerprints, will that affect the approval or her next visa?
Okay. In order to avoid unlawful presence in the US, you have to either change your status or extend your status prior to its expiration. Prior to its expiration. If you do that later, you would have had to have filed it with a request for nunc pro tunc. That means relating back to the date of expiration, and ask the USCIS to use their discretion in granting the nunc pro tunc approval. If they don't, she has been accruing unlawful presence since the expiration of her I-94. And if you are unlawfully present for more than 6 months, you are barred from reentering for, there is that 3-year, 10-year ban. And so you would be subject to that at this point. So what I would suggest is if she's eligible and she can file for permanent residence, if you're a US citizen, then that's probably a better route to avoid having her go through the, bar, being subject to the bar.
Another anonymous attendee, is it better and cost effective to apply for a green card and the H-1B at the same time versus applying for it at separate times?
I don't know if it's really cost effective, but there's no bar from initiating both of them at the same time, especially if there is some issue in terms of time sensitivity with relation to, your 6 years being exhausted. We've done that a lot of times where it's, the company was working with another law firm because we try to keep that on our radar, and they didn't realize that they needed to file within a certain time frame to leverage the extensions beyond the 6 years. And so we would file them simultaneously.
Well, that was the last question, but there is an anonymous attendee says, hi, Shaker, looks like you have missed my question I sent in the beginning of the call. Well, it says it happened a few times like this. I'm not sure what is the issue. I'm sorry if I missed it, but I think the first anonymous attendee question we got it at 12:26 p.m. And I think I did ask that question on air, and Lakshmi did answer. I'll ask again. And that was the first anonymous attendee, 12:26. Can you please provide some update on the receipt notice for I-140, I-485 concurrent downgrade cases filed last week of October? Have you received it for all the cases your law firm has filed? How much longer can we expect to get the receipts? Thank you. And I'm pretty sure we did answer this question.
We did, but if that's not the question
that's not the question, then just let us know, because the next anonymous attendee, and I just want to make sure that, I'm sorry if I missed it. I don't want to be, branded as missing questions. I have no partiality because I don't see the name. The next anonymous attendee question came at 12:40. Can you please do a webinar for small businesses wanting to expand to US? We answered that too. And then 12:44 and 12:45, which are recent ones. So Mr. or Miss Anonymous Attendee, I apologize. I think we answered the first one that came at 12:26, but if you
want to send it again right now, we can answer it before we close off.
Put a question there right now, and Lakshmi will answer it. But if you already left for the day or exited the webinar, please do send an email to info@Challa Law. So we'll wait for a minute or two, and Lakshmi, I'll pass it on to you to conclude while we are waiting for that gentleman or lady to post a question.
Okay. So thank you all for attending. Happy celebrations, whatever it is you may be celebrating today. And, as I said at the very beginning in 2021, these weekly webinars are going to be more and more critical as we get through the year, because we're going to have a lot of changes that are taking place. And we are specially positioned to kind of get the inside info on those changes. So we can pass that on to you, and not only what the information is, but how can you, outline your immigration strategies so you can leverage the maximum amount of benefit from those changes. So stay tuned, keep sticking with us, and send out 5 emails today to your friends and have them join us on Telegram and here. And I think Shaker's got the question now.
Yeah, this gentleman has put the question. I have not seen that question. It's a long question.
You probably put it, sir or madam, in chat.
It's not in the it's not in the chat either. But anyway, let's answer the question. My I-140 is approved and I have my EAD with employer A, and it's past 180 days of 485 application in process. I'm planning to switch to employer B, and can you please clarify below items in this context? Is it mandatory to apply AC-21 with new employer B?
Remember, I just want to...
4 questions. I'm going to read one at a time so you can answer.
I just want to say, just to make sure we've got the context clear, your I-140 has to be approved, excuse me, and your 485 has got to be pending for 180 days. Those 2 prongs have to be met. It's not enough if 1 is met, 2 have been met. And the question was, is it mandatory to file an AC-21 with the new employer? Yeah, you have to file a 485J.
So both the conditions have to be met. I think this person's 140 is approved by EAD with employer A, and past 180 days, 485 application is in process. So that means it's not approved.
Right,
okay.
But that's then if your I-140 is approved and your 485 has been pending for 180 days, you are eligible. You can change employers with your EAD. You still must file. You have to notify the USCIS that the job is same or similar than your perm application. So you do that through the mechanism called the 485J.
So the second question is it mandatory that my position title and job duties be same with employer B as employer A, or can this be different even though I did not get my green card in hand yet?
Right. So the Trump administration, before it was very broad. The criteria was same or similar. It didn't have to be the same SOC code. It didn't have to be the same salary. They would just look at the duties. And you do that by showing your perm and what the duties are, and talking about your new role and trying to make sure that they interrelate. The Trump administration has changed that in that they want to narrow it. So they are looking at the SOC code. They are looking at other things. I'm pretty sure that this is also going to be readdressed with the Biden administration. But I always think the title doesn't have to be the same. It's the duties that are most important. So it's important you interlace the duties that were on your perm with the new position that you will have, so that it's easy from an optics perspective to see the relationship of same and similar.
So his third question is there any dependency with employer A in brackets after moving to employer B on EAD, brackets closed, and does employer A need to support anything until I receive my GC?
No, not if you're porting, no.
And his last question, what kind of immigration support does employer B needs to do in this case until I receive my green card other than filing AC-21?
Right, so the I-45J would be signed both by the employer and employee. So that they would need to file that.
Okay, while we are just last question is from Mukesh Nagar. Any idea why DOL is taking 6+ months for permanent perm processing currently?
No, I think there was some delays in the summer. There may be more coming up because they've expanded the H-2Bs. Because remember, H-2Bs have to go through a labor certification process, and every time they're that quota is issued twice a year, in June, and I think it's in June, in the summer, and right around this time. So every time they're processing that, the perms get delayed. And right now, there was a new rule that came out yesterday that they're expanding those numbers. So it may be even further delays.
That's it. And like I said, if you didn't get your question, I think all the questions now I've exhausted. And please do send an email to info@challalaw.com. And Lakshmi,
Yeah,
thank you
until
for the
then, have a great week. Have a safe week. Look forward to talking to you again next week. And this is me. Peace out.